Good morning, everybody. We're going to allow just a few moments here to allow the Zoom room to populate. I can see the audience filing in. Just another note that we are allowing the Zoom room to populate, and we'll give it another 30 seconds or so to allow participants to join.
Okay.
Great. Good morning, everybody. I see that people are still filing in, but the numbers have slowed down, so we will get things started with our panel this morning. My name is Michael Berger. I'm the Executive Director at the Sabin Center for Climate Change Law at Columbia Law School here in New York City. And it's my pleasure to be the moderator for today's panel. In this moment of climate crisis, a worldwide energy transition is underway. It is in its early stages. It is proceeding in bursts and in stops, and it has a long course to run to reach its end. But the climate crisis and the energy transition are not merely a technological shift or a series of infrastructure changes. It is felt and experienced by individuals, by communities, by companies and industrial sectors, by investors located in different places in different ways. As the international community, individual nation states, and subnational governments take measures to decarbonize the global energy system, the distributional impacts of this transition must be taken into account. Today's panel offers us a unique opportunity to reflect on the role that international and domestic legal frameworks can and do play, and the role that they should play in addressing those impacts. So we have an outstanding panel of experts and leading voices in this field from the scholarship community as well as the practitioner community. So I'm going to jump right into turning things over to them. I'll begin by providing an introduction to our four panelists and a very brief overview of the trajectory of the presentations we'll be hearing from them. We'll be hearing first from Martin Dietrich. Martin is a senior legal and economics researcher at the Columbia Center for Sustainable Investment, our co-host for today's panel, where he focuses on extractive industry investments in the context of sustainable development and the low carbon transition. He also focuses extensively on investment law and policy. He speaks 4 languages and regularly works with developing countries in trainings, in advisory work, and in other collaborative efforts. We'll next hear from Kyla Tianhara. Kyla is Canada Research Chair in Economy and Environment and Assistant Professor in the School of Environmental Studies and Department of Global Development Studies at Queen's University in Kingston, Ontario. She is a leading scholar on investor-state disputes concerning environmental regulation and has been writing in recent years a great deal about the relationship between investor-state dispute settlement, climate change, and compensation. Next, we'll hear from Blanca Gomez de la Torre. Blanca is a partner in dispute settlement at ESIJA, one of the largest Latin American law firms. Blanca has over 20 years of experience in civil, commercial, administrative, and national and international arbitration and litigation. Her professional practice has also been linked to the areas of national and international public law, competition, finance, banking, and aviation. Importantly, Blanca has acted as counsel for parties in investment and commercial arbitrations under ICSID, UNCITRAL, and ICC rules, among other things. Among her many other engagements and commitments in the legal community in Quito, she has written extensively about Ecuador's experience with investor-state dispute settlements and is a professor of alternative disputes resolution and commercial arbitration at the University of San Francisco, Quito. And then finally, we'll hear from Dave Jones. Dave is the global program lead at Embra Climate an international energy think tank focused on the transition from coal to clean energy. And Dave will be talking to us a bit more about the domestic context in a recent case study that he did in Germany. So just to give you a quick overview again, and I've touched on this briefly, we'll begin with each panelist offering approximately a 10-minute intervention. Martin will kick things off by setting the stage and providing us with an overarching context for the discussion. Kyla will then take a deeper dive into the valuation of fossil fuel assets under the investment law regime, including the Energy Charter Treaty. Blanca will then focus on valuation of fossil fuel assets in concluded ISDS cases. And then finally, Dave will address the issue of valuation of fossil fuel assets under domestic legal regimes, focusing on a case study of Germany's compensation scheme for lignite producers. There will be plenty of time for Q&A at the end of the presentations. So I do encourage you to, at any moment during the presentations, start logging your questions into the Q&A function of the Zoom chat. I will be reading those throughout the presentations and lining up questions for this session that will follow. We will conclude at 10:30 as a hard stop Eastern time. So with that, Martin, I'll turn it over to you.
Thank you very much, Mike. It's a pleasure to be with all of you here today. I'm most excited to learn from my co-panelists who will focus on the valuation of fossil fuel assets in a changing climate and on issues of compensation under investment treaties and arbitration, as well as under domestic compensation schemes. But before we go into compensation for fossil fuel investors, I'd like to invite all of us to reflect on what compensation should mean from an equity standpoint in the context of climate change and the energy transition, and the role that international and domestic law have in shaping what it means. Achieving the 1.5 degrees Celsius goal of the Paris Agreement principally depends on a shift away from fossil fuels and toward renewable energy in the next couple of decades. The 2022 report on climate change mitigation, recently released by Working Group 3 of the Intergovernmental Panel on Climate Change, the IPCC, appropriately recalls the challenging equity dimension of the energy transition and the distributional impacts that Mike, our moderator, has just alluded to. The IPCC notes, quote, ambitious mitigation pathways imply large and sometimes disruptive changes in economic structure, with significant distributional consequences within and between countries, unquote. Within countries, distributional consequences include the shifting of income and employment from high to low emission activities. Jobs in fossil fuels and other high emission activities will be lost, even if new jobs will be created in the zero carbon economy. Between countries, distributional consequences include the negative impacts of the transition on developing countries whose economies and government revenue depend heavily on coal, oil, and gas. Besides often being the most vulnerable to the physical impacts of climate change, fossil fuel dependent countries are the most exposed to the negative economic and fiscal impacts of the zero carbon transition, which will disrupt their fossil fuel value chains, even if they can take steps to manage those challenges. Equity is therefore integral to climate and the energy transition. It refers to how costs and benefits are distributed according to social contracts, national policy, and international agreements, as the IPCC puts it, acknowledging the role of domestic and international legal frameworks. Several conceptual frameworks are relevant to taking equity into account in the context of climate and the energy transition. In particular, just transition, which made it to the title of our webinar today, and the broader notion of climate justice. At the basis of these equity frameworks is an acknowledgement that climate change and the transition are inherently disruptive, with different impacts on different stakeholders, in particular with disproportionately negative impacts on communities and countries that depend on fossil energy or are otherwise more vulnerable. Equity has a distributive justice element. Beyond recognizing that impacts are disproportionate, it calls for deliberate action to minimize negative impacts on the underprivileged and achieve a fairer sharing of burdens and benefits. It also has a procedural justice element. It calls for equitable access by those most vulnerable and disproportionately impacted to meaningfully participate in decision-making processes, including transparency and accountability mechanisms, to ensure that their needs are appropriately taken into account and, to the extent possible, met. A mention to just transition made it to the preamble of the Paris Agreement, and several international documents flesh out what a just transition means in practice. The International Labour Organization, ILO, published its 2015 guidelines for a just transition towards environmentally sustainable economies and societies for all. Those guidelines were negotiated between governments and unions of employers and workers. Also, a number of heads of state and government signed just transition declarations at two recent UN climate conferences, COP24 in Katowice and COP26 in Glasgow. The 2022 IPCC report I just mentioned on mitigation usefully summarizes the just transition framework. And I find the wording excellent and applicable to equity frameworks more broadly. So I'll quote liberally from it here. Just transition comprises, quote, a set of principles, processes, and practices aimed at ensuring that no people, workers, places, sectors, countries, or regions are left behind in the move from a high carbon to a low carbon economy. It includes respect and dignity for vulnerable groups, creation of decent jobs, social protection, employment rights, fairness in energy access and use, and social dialogue and democratic consultation with relevant stakeholders. A just transition entails targeted and proactive measures to ensure that any negative social, environmental, or economic impacts of economy-wide transitions are minimized, whilst benefits are maximized for those disproportionately affected. These proactive measures include eradication of poverty, regulating prosperity, and creating jobs in green sectors. In addition, governments, polluting industries, corporations, and those more able to pay higher associated taxes can pay for transition costs by providing a welfare safety net and an adequate compensation to people, communities, and regions that have been impacted by pollution or are marginalized or are negatively impacted by a transition from a high to low economy and society, unquote. So just transition has become an internationally recognized framework to take into account equity in the energy transition. Equity frameworks are also relevant in climate-related issues that are adjacent to the energy transition. For example, the need for compensation for loss and damage associated with climate impacts, such as extreme weather events and slow onset events. The equity equation is a complex one, but it's important as well as beneficial for us to consider. The IPCC report indicates, for example, that paying attention to equity, including meaningful participation of all stakeholders in decision-making, can build social trust, increase social acceptance and effectiveness of climate mitigation policies, and allow faster climate action and higher levels of ambition. So let's keep equity in mind as we go into today's main topic, compensation for fossil fuel assets. And we'll hear next from our brilliant colleagues here about how much, if anything, should be paid as compensation to fossil fuel asset owners, what criteria should be applied to calculate those amounts, and who should make those decisions. Currently, many international and domestic legal frameworks create privileges for fossil fuel asset owners to receive compensation from states. Fossil fuel asset owners are exposed to transition risks and costs, yes, but their exposure doesn't translate into vulnerability. Fossil fuel companies, besides having long known that they're major sources of the greenhouse gases that cause climate change, generally have substantial economic capability to insure themselves against these risks and can afford any uninsured costs. Current debates and practices on compensation for fossil fuel companies ignore the fundamental broader questions on the distribution of costs and benefits, including who is effectively more vulnerable to suffering the risks and bearing the costs of climate change and the energy transition, who can afford to bear those costs, and relatedly, who should pay compensation and who should benefit from compensation. I propose the following principles on equity considerations and legal frameworks on compensation for climate and the energy transition. Domestic legal frameworks should primarily focus on benefiting workers affected by the phase out of fossil fuels, who will need compensation in the form of severance packages, social safety nets, and resources and opportunities for retraining and upskilling. Domestic schemes should also primarily benefit other local and indigenous communities and broader populations and taxpayers directly or indirectly affected by climate and the energy transition, including the impacts of economic diversification away from coal, oil, and gas on other industries beyond energy, eventual increases in energy prices, social and environmental impacts of increased mining of critical minerals and metals needed for the energy transition, and economic, social, and environmental impacts of the closure of coal mines and decommissioning of oil and gas fields and infrastructure. In turn, international legal frameworks should focus on ensuring that states have adequate resources to invest in climate mitigation and adaptation, and to cover the growing costs of loss and damage. Compensation should be available, especially for lower income countries that are most vulnerable to climate and transition impacts and have least access to public finance. If companies are to be compensated, smaller ones, especially in non-energy sectors that have to retrofit their operations because of the transition, would rank higher than larger ones as potential beneficiaries. International fossil fuel companies, especially companies that continue to recklessly invest in fossil fuel exploration and extraction, would rank the lowest. Any compensation a fossil fuel company might receive should, at a minimum, be conditioned upon specific enforceable just transition obligations on the company for the benefit of its employees, and conditioned upon the explicit provision or prohibition of reinvesting any compensation received in fossil fuel projects and related infrastructure. International law should be the steward of distributive and procedural justice in climate and the energy transition. In the context of investment treaties and arbitration, which Kyla and Blanca will talk more about, states should not put private arbitrators in the driver's seat in issues of valuation of fossil fuel assets and compensation on a case-by-case basis. Instead, states should bring these discussions to a state-led decision-making forum, possibly under the existing climate change regime, that would define principles and criteria on compensation, including on compensation to developing countries for loss and damage and for keeping their fossil fuels in the ground. Such an international forum should also include procedural justice mechanisms to ensure that the input from those affected and vulnerable is taken into account, their rights realized, and their needs met as possible. Finally, to conclude, international law should also embed commitments by states to translate those principles and criteria of distributive and procedural justice into their respective domestic legal frameworks and mechanisms. For example, just transition or climate justice commissions or task forces or compensation schemes, mindful always of countries' different priorities and capabilities. I'll stop here. Thank you so much. And I look forward to listening to others and also to our discussions later.
Great. Thank you so much, Martin, for getting things started with the overview and your provocative proposal for these principles to guide the just transition and compensation schemes. Next, we'll hear from Kyla.
I feel that that's a tough act to follow because that's such a beautiful vision that Martin has laid out for what international law should be. And instead, I have to tell you what it actually is, which is nowhere near providing any kind of justice or equity. So I'll get right into it because I've probably got too much to cover here for 10 minutes. So I want to just start by sort of sharing the 3 questions that I've been using to try to organize my thinking on this topic. So the first is the broad and somewhat philosophical question of whether fossil fuel investors should receive any compensation when their assets are stranded as a result of government policies. The second is more about process. If there are circumstances in which compensation is merited, who should decide on what amount is appropriate? I think Martin's already addressed that a little bit, but I will as well. And then third, if there is some kind of role for international investment arbitration, do we need to reform the current investment treaties in order to place limits on the amount of compensation that can be awarded by tribunals? So I will return to these three questions at the end. But first, I feel like I should give a bit more background in case there are people in the audience who aren't sort of deeply into this, this area of international law. So let me just go through this a bit quickly. We have over 2,600 investment treaties currently in place. They've been around since the 1960s, but really it was the 1990s where we saw this big boom in these kinds of treaties emerging. And we have a couple different types. So there are bilateral investment treaties between two countries. There are also treaties with investment provisions. These are usually regional trade agreements, NAFTA, which has now been replaced by the USMCA, which does not exactly have a traditional investment chapter, but NAFTA is still operating for a few years. We also have others like the Comprehensive and Progressive Trans-Pacific Partnership, or CPTPP, which I always have to note is neither comprehensive nor progressive. We also have the Canada-Europe deal known as CETA, and so forth. There's many of them. Also want to highlight the Energy Charter Treaty, which is unique in that it only covers the energy sector. It's mainly European countries, but also Japan and some others. This has been an important one in some of the cases that I will share, and it's also undergoing currently a modernization process. And there's a lot of talk also about potentially terminating or withdrawal from the treaty. So what these treaties generally do is protect foreign investors and investments from so-called direct and indirect expropriation, which can include regulation. States are also required to provide most favored nation treatment and national treatment. In theory, this is about preventing discrimination, but it can be interpreted quite broadly. Also, probably the most problematic provisions are requiring so-called fair and equitable treatment, which has been interpreted as requiring basically states to provide some level of stability to investors and insulate them from changes in policy. The language on these standards is very vague and open to interpretation. And in terms of who is doing the interpretation, if there's a dispute, it's resolved in investor state dispute settlement, or ISDS. This is a process where a panel of 3 arbitrators is set up, one chosen by the state, one by the investor, and one that is mutually agreed upon. There are a lot of problems with this process that I don't have time to get into in this short presentation, but I would direct anyone who isn't familiar with the problems to this wonderful CCSI primer. The link is there at the bottom. It's got beautiful illustrations, tons of links to all the different issues that are raised, and it's really a fantastic resource. So getting back specifically into the question of compensation for fossil fuel investors that are impacted by climate policies, the idea of legitimate expectations is likely to be central in any cases that get to our investment arbitration. So for example, companies will argue that they have legitimate expectations to be able to extract further fossil fuels, even if they only have received an exploration permit, if they find a viable deposit. And so if a government bans further extraction, they will say that their exploration permit gave them a legitimate expectation that that ban would not apply to them. So this kind of argument has a number of flaws. First, there's a lack of any sort of real basis for the idea that investment treaties should confer any form of legal stability. Legitimate expectations is really something that investment lawyers and arbitrators have invented. The notion is also philosophically flawed. And on this point, I would highly recommend that people take a look at the submission by Dr. Fergus Green to the OECD consultation on investment treaties and climate change. I can put a link in the Q&A later. A lot of the submissions there are actually quite worth looking at. But he particularly focuses on this sort of philosophical question about legitimate expectations. So in addition to the problem of legitimate expectations generally, specifically with fossil fuels, it's a flawed argument because in the climate space, we have international cooperation on this issue dating back at least to 1992 with the UNFCCC, which this should have sent a clear message to investors that action was going to be taken. As Martin noted, they have long known that they are the primary cause of the problem. And then I also think that one of the main reasons why we haven't seen significant action taken by governments up to this point is because policies have been obstructed at every turn by the fossil fuel industry and their supporters through means such as the spread of misinformation about climate change and extensive lobbying and so forth. Therefore, any expectation that the industry would be able to continue on with business as usual is a creation of the industry itself, and therefore it should not be considered legitimate. Having said all of that, this is my view as a scholar and a climate activist. I am not an arbitrator, and I very much doubt that most arbitrators would agree with my position on this. There may certainly be some, but I'm concerned that many arbitrators would place a higher value on commitments made by states to further exploit fossil fuels rather than on their commitments to fight climate change. We don't yet know how tribunals are really going to deal with these issues because we haven't had any climate cases decided on the merits. There also isn't any precedent. So even if we do get a case, we can't say that all the cases are going to go the same way. Nevertheless, I think that we can say that there are some concerning trends in the types of claims that have been emerging. So I'm going to quickly run through a few of these. So first up, Rockhopper v. Italy is a case where a firm with an exploration permit for offshore oil is challenging a ban on oil operations off the Italian coast. So this isn't purely a climate case. The communities who campaigned against offshore oil were also concerned about the impacts the spill could have on tourism and fisheries and the marine environment, but is clearly relevant to our discussion. The case is ongoing under the ECT, and there's really not a great deal of information about it. There is sort of an expectation that it might be decided in the near future. Next, we have Westmoreland Coal versus Canada. So several years ago, the province of Alberta committed to phasing out coal-fired power by 2030. And because the province doesn't really have the infrastructure to export coal, that resulted in a de facto phase out of local thermal coal mining. In order to ensure support for the plan, major utility companies in the province, which all happen to be Canadian, were provided with transition payments to facilitate the switch to gas and renewable energy. But the US mining firm Westmoreland did not receive a government handout because it was not transitioning to anything else. But Westmoreland claimed that this was discriminatory. So this goes back to what I said about, these treaties theoretically are just covering things like discrimination, but it's twisted in these bizarre ways by companies and lawyers. This claim was thrown out on jurisdiction, so we unfortunately aren't going to learn very much about what the tribunal would have thought of the climate aspects. Another coal phase-out story in Europe. In December 2019, the Dutch government legislated to ban coal-based power generation by 2030, and this caused two companies that had recently built coal power plants to bring actions under the Energy Charter Treaty. And notably, a spokesman for one of the companies, RWA, said that the phase-out was not legal because it does not include adequate compensation for this interference with the company's property. I'll get back to the point about adequate compensation in a moment. And then finally, we have the cancellation of the Keystone XL pipeline. This was a project to bring tar sands petroleum from Alberta through parts of the US. It was extremely controversial. It was first canceled by Obama back in 2015. That sparked a NAFTA dispute and a claim for $15 billion in compensation. Trump came along, reversed the decision, and the company moved forward, dropped its case, but then Biden canceled it again on his first day in office. So TC Energy, the Canadian company behind the project, has again launched a dispute for $15 billion under the legacy provisions of NAFTA. And interestingly, the government of Alberta, which invested public money in the project, has also launched its own case, which is quite fascinating. So as should be clear from the numbers that I've just thrown at you from some of these cases, the compensation that investors are seeking in ISDS is very high. So they are seeking not just their sunk costs or what they actually spent on investment prior to a treaty breach, but also speculative lost future profits. And tribunals are increasingly willing to award lost profits, which has led to an increasing number of very large ISDS awards. So according to one report, the average amount that states were ordered to pay in ISDS between June 2017 and May 2020 was $315.5 million, But another report from IISD, which came out last December and is focused on fossil fuel disputes, found that in those cases, the average was much higher at around 600 million. And you can see on this chart here that substantial amounts of public funds have been flowing to carbon majors through ISDS. Now, there are a lot of problems with the idea of awarding lost future profits to firms, but my main concerns is that, well, it creates moral hazard and could end up inducing more investment in fossil fuels, but it could also cause regulatory chill. And unfortunately, I think we already have some preliminary evidence that this is occurring. So we have the case of France, where there was a threat of ISDS from a company called Vermilion, and subsequently the country's oil and gas phase out was redrafted to allow existing permit holders to renew their permits. Denmark, which is one of the two initiators of the Beyond Oil and Gas Alliance, or BOGA, reportedly set the deadline for its oil and gas phase out at 2050 in order to avoid ECT claims. And we have the climate minister of New Zealand on record saying that the country did not join BOGA as a full member because the government was concerned that a Paris-aligned phase out of oil and gas would have sparked ISDS claims. And then in addition to chilling effects, it is also possible that climate policies will go ahead, but will just cost more. So in the case of the Dutch coal power phase out, the government had developed a mechanism to calculate compensation for impacted investors. However, the maximum compensation for RWE, which was 512 million euros, and Uniper, which was 51 million euros, was apparently deemed insufficient by these firms, with each choosing instead to launch claims of over 1 billion in arbitration. So independent economic analysis by the groups IEFA and Ember suggests that the plants were already loss-making before the phase-out was announced, which indicates that a win in ISDS would be a real windfall for these investors. And then there's the German coal power phase-out, which I won't go into depth because we have a speaker talking about the compensation scheme there, but I will just note that it was a negotiated scheme and that there was, it has been noted that the contracts included explicit provisions to prevent ISDS cases. So there's been speculation that a threat might have been made that if the amount wasn't high enough, that the companies would turn to ISDS. Now, all these examples that I've given are from the global north, but I do want to emphasize, especially, getting back to Martin's whole equity framing, that the implications of all of this are much greater in the global south. So Germany, Netherlands, Canada, we can all probably afford to pay out these investors, but the implications are much more serious in other countries. So I'm short on time, but I want to sum up by returning to the three questions that I posed at the outset. So the first is, should fossil fuel investors be compensated when their assets are stranded by government action on climate? I would argue no, based on my assessment that there should be no expectation of policy stability. However, I can still see that a government might wish to offer some compensation purely to get the impacted investors to shut up and go away and speed up the process of phasing out fossil fuels. And ultimately, we all want the process to go quickly in order to keep warming as low as possible. In such circumstances, it should be the democratically elected government that decides what compensation is appropriate. However, the problem that I see is that so long as investors have access to ISDS, they can either pursue more compensation in arbitration, as we see in the case of the Dutch coal phase out, or wield the threat of arbitration in negotiations with the government, as I suspect might have been the case in Germany. So what do we do about that? My first preference is always that we terminate these treaties because they are serving absolutely no public purpose, public benefit. They don't actually facilitate investment in areas that we want to see investment. So we should just get rid of them. Carving out the fossil fuel sector from ISDS is another option that has been put forward. In the absence of agreement among states on these approaches, we could also push for hard caps on the amount of compensation that can be awarded by tribunals. One simple approach would be to limit compensation to just sunk costs. A more sophisticated approach has been developed by Aisbett and Bonaccia in 2 papers that were published last year. They also have made submissions on this topic to the OECD consultation on climate and investment, which again, I would recommend you look at. And their approach would leave fossil fuel investors in most, if not all cases, with zero compensation. So that would obviously address some of my main concerns about regulatory chill and raising the cost of the energy transition. So thank you very much for listening. Happy for feedback in the Q&A, and also happy to reach out to me by email or Twitter. And thanks again to the organizers for this session. I really look forward to hearing the other presentations.
Thank you, Kyla, for that very informative presentation. That was great. Let me take a quick moment to remind the participants and audience to please log questions that you would like to have raised during the Q&A section of today's event in the Q&A section of the Zoom chat. I see that there are a couple of questions in there, but we will have some time, 30 minutes or so, I expect, for discussion. I would love to bring your questions to bear. Next, we'll hear from Blanca. Blanca, over to you.
Well, it is very hard for me to follow all the previous speakers, because they are speaking about what is good for the planet, what is good to have it. But I'm going to speak about the reality, what is going on investment arbitration. And let me begin first by saying how it works. Parties in international arbitration most commonly claim monetary compensation as the remedy. To calculate that compensation, tribunals may use different approaches when calculating damages within an investment arbitration. In the case of lawful expropriations, investment treaties usually require payment of the fair market value of the expropriated investment as of the day prior to the taking. We can find out this provision in BITs like the one signed between USA and Argentina. As an exception, some tribunals have applied this standard to unlawful expropriations, such as the case of TechMed versus Mexico, MetaCloud versus Mexico, or Huarachi America Inc. and Ruralec versus Bolivia. But when we speak about unlawful expropriation or other treaty breaches, tribunals usually apply the customary standard of full reparation, which were, for example, used in Burlington versus Ecuador or Crystalex versus Venezuela. This principle, developed in the case concerning the factory of Short-Solve, provides that reparation must, as far as possible, wipe out all consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed. Full reparation, therefore, usually covers fair market value, any increase of value of the investment from the date of expropriation up to the date of the award, any consequential damages, which could, for example, include loss of chance, as in the case of Perenco versus Ecuador, where the tribunal awarded $25 million to Perenco for the loss of opportunity to extend the contract for the operation of an oil block and moral damages. Unless the treaty sets out a evaluation methodology to be used to assess damages, arbitral tribunals can select the appropriate methodology at their discretion. For example, in Murphy versus Ecuador, the tribunal found out, and I'm going to quote, the choice of the evaluation methodology has a significant impact on the final damages calculation. The applicable international law standard of full reparation, as reflected in the Chorso factory judgment and Article 31 of the ILC Articles on State Responsibility, does not determine the evaluation methodology, nor does the tribunals enjoy a large margin of appreciation in order to determine how an amount of money may, as far as possible, wipe out all the consequences of the illegal act and reestablish the situation which would, in all probability, have existed if that act had not been committed. So in order to calculate the fair market value, we have three main approaches used by tribunals. The first one is the income-based approach, which includes the discount cash flow DCF analysis. The second is the market-based approach or comparison approach, which uses the stock market comparison to calculate the damages. And the third one, which is the less used one, is the asset-based approach or cost approach, which entails the need to check the books of the company and the real investment. These three main approaches are not mutually exclusive, but the first one, the income-based approach, is the most commonly used because according to most of the tribunal findings and doctrine in investor-state arbitration, it sets an account for the true value shareholders can extract on the investment, and it accounts for the specific risks associated with claimant's investment. On the downside, it requires an exercise of forecasting and discounting, which not always is in the practice real and is equal or to what is really happening in the future, and may tend to be speculative. Therefore, let me focus on the income-based approach, as it is the most commonly used for the calculation of damages. And it consists in two parts. One, an estimation of a company's expected future free cash flows. And the second, the discounting of these cash flows to the valuation date using an appropriate discount rate. Cash flows comprehends revenues, operating expenses, capital expenses, taxes, and changes in working capital. You have not seen anything about decarbonization or climate change considerations. In the case of petroleum concessions, key parameters include the estimated number of barrels of oil produced and sold, the price of oil to calculate it. They examine value, quality, and size of the deposits. In the case of Occidental versus Ecuador, the tribunal explained, when reserves are estimated, it is a standard practice in the oil industry business to adjust them according to their category in order to estimate future productions. Such estimates are used in the actual planning and operation of oil extraction, as well as for financial reporting purposes, including future profit forecasts. The second criteria is the company's historic and future production capacity and sales. The third one is the market data or analysis estimate for future oil prices. For example, in Burlington versus Ecuador, the tribunal used the long-term price forecast, while in Phillips Petroleum versus Petróleos de Venezuela, the tribunal used a forecast for a shorter time period while adjusting prices by inflation beyond the short-term horizon. Fixed term nature of contract in those industries is another criteria to be used to determine the forecast. And that was the case of Burlington versus Ecuador, where the tribunal used it as a temporal limit for the calculation. In my experience, non-tribunal has had the approach to consider the changes in oil prices that a successful transition towards renewable energy might entail. Neither the fact that assets may suffer from unanticipated or premature write-downs, devaluation, or conversion to liabilities due to the need to decarbonize. But the treaty silence leaves significant room for tribunals to adopt claimant-informed approaches to valuation and damages. And therefore, because tribunals have not limits to it, they can make decisions based on arguments and facts related to climate change and climate science that did not exist previously based on public or private law. I do not dare to sustain they are the right venue, neither they are the wrong one. The fact is that they are the one that does it. So we must help them to find out the best method and the best way to calculate compensation, taking into account the need to decarbonize. The question there is, who is going to endure the cost of decarbonization, the state or the investor? And we must take into account that on the one side, for example, the Inter-American Development Bank has placed the burden to move toward decarbonization on states. And on the other side, companies in the energy industry have also faced pressure from governments, shareholders, and activists to work together to deliver a sustainable future for our generations to come. So the question to be answered by tribunals would be, if we are going to take into account for the price oil determination or the compensation to investors, the need to decarbonize, who is going to endure it? Are the states or are the companies? Thank you very much.
Blanca, thank you so much for your intervention. Thank you so much for the clear elucidation of the principles and doctrines that are applied by the arbitration panels. It's an important contribution to the conversation. So we'll turn it over to our last speaker, Dave Jones, who has started sharing his screen. And I will remind folks once again to please do feel free to log any questions or comments into the Q&A. Dave, over to you.
Yeah, hi, I'm trying something that I've never tried before, which is superimpose myself over the slides. Let's see if this works. If it doesn't, I'm gonna just quickly cut back from it. I don't know why I'm doing this. I just want to, I've been asked to talk a little bit about a specific case study, which is around Germany's lignite compensation case that I was involved with. A little introduction to ENVA for those of us who don't know us. We're a global electricity think tank trying to accelerate the speed up from coal to clean electricity. Our kind of niche is turning data into action. So actually getting involved in a actual compensation case with actual numbers was very exciting for us to do. What we did was we got given behind the scenes, Greenpeace Germany got a freedom of information request from the German government about the formula by which they calculated the compensation for lignite. They shared it with us. We were able to do some analysis. And then we shared that analysis with press in Germany, the press release, and we got all sorts of conversations and follow-ups happening from that, which we were very happy with. And what we managed to work through was and highlight was three flawed assumptions within that formula for compensation that made the whole 4.4 billion euro package a little bit quite obviously unfair and too generous. I've just got some notes here that I need to squeeze past. Not easy to, yes, so Kyla mentioned about the European Charter Treaty. This was, well, we have been involved in that separately, and Sarah was meant to be here speaking on that. She did some modelling on the RWE and Uniper plants that have doing that legal case in Netherlands. I wasn't involved in that. The German case is actually under German law, with so wasn't actually in an international context, and actually even more specifically, it really was a bilateral deal between the two lignite companies, RWE and LEAG, and the German government by itself. So I guess the reason why the three assumptions and overcompensation came about in the first place was really unsurprising, given that there were two parties around the table. The German government really wanted a deal on this, and the experts in the room were the two utilities who were able to negotiate the terms. And why our interest in the case was really the precedent, so less about this in itself, but more about the precedent across the whole of the rest of the world. So when we're talking about and this is kind of where Martin started a little bit with his piece, and the vision that he had was, if we, in this world where we're rewarding fossil companies to close their plants and to stop extracting fossils or burning fossils, this is going to be a heck of an expensive energy transition across the world. We can't be in a position where we're rewarding companies to do that. And more importantly, it's like, if you do have cases like this, it's really slowing the transition. Because if you're a fossil company, you're just going to be sitting there with your hand out, just waiting for compensation. It gives completely perverse incentives for companies to keep on business as usual, and then wait for governments to bail them out, because it's the governments that want to then reduce need to reduce their emissions, so they need to go back to those companies and then pay them to. So this whole context around compensation really has the potential to slow down the whole of the energy transition and put our climate targets at risk, which is really alarming. There were three things that we came up with within the formula that just didn't make sense at all. So I'm just going to run through them one by one. The most obvious one was when they assessed the compensation, they said, oh, what were these assets worth back in 2017 to 2019? Actually, what happened was power prices crashed off in 2020, continued falling into 2021. So when this package came out, actually the assets were worth 143 million euros on the same formula as the German ministry valued them at 4.4 billion euros. So you're like, well, what's a fair price to put them against? And so often if the companies are in charge of or have a strong say in the negotiations, they know which time periods to mark against. And the other one was Blanca was talking about some of the like how you calculate the cost and the assumptions going into the models. One of them was that they didn't even include fixed costs within there. So they're including purely variable costs. You include a portion of fixed costs. Not all the fixed costs are avoidable. So you've got to be, just to put all the fixed costs in there actually came out as a negative valuation, that these were loss-making assets, but only some of those fixed costs are actually avoidable. And that again, it's this issue of subjecture, where if you're the fossil company, you can dominate that negotiation, and you need someone on the other side to be asking, but like, how many of these are actually avoidable? And the third one, which again will impact all of valuations, is how long do you want to make that payment for? So the formula was across 4 to 5 years of payment. But actually, when you look at the company plans, LEAG had actually already promised to close all their power plants by the end of earlier than that. So in theory, they shouldn't have been paid any of that compensation. So you go through and then you add all these three up, and then the sum total of these three is to take 4.4 billion euros of compensation down towards zero, depending on which assumptions you choose within this. So I just wanted to highlight those three assumptions, because those three assumptions that applied for German lignite certainly apply for other forms of asset valuation. Why is it unfair to these companies? Is the IPCC that Martin started talking about from last week. We need 50% reductions by 2030. Coal power in particular takes most of that brunt in this first decade. So if you're a coal, these issues are really, really pertinent for coal power producers, because we need such big falls to keep on track for 1.5 degrees. And if you need such big falls of 3/4 of the world's coal power generation in the next 8 years, I don't know why I'm looking at my clock to work that out, not long, basically. How are you going to go through that? So here are 10 of the world's the world's 10 biggest coal power countries. And what you're looking at now is trying to work out on a fairness back, like we were talking, Martin started talking about fairness and who burdens the costs of this. From a country perspective, how aggressive should countries go if global coal power is going to fall by 3/4 within the next 8 years? And it really opens up the questions for a lot of that. And I'm not going to, maybe we'll go to in the questions, but I don't want to take up time now and go into some of those country discussions. But there is a really, really big movement at the moment to, it started off with the Asian Development Bank to come up with mechanisms for coal plant closures, and that's been discussed around all sorts of levels. So you may have seen at COP, South Africa deal with I've completely forgotten the name of the South African president, about a deal with the UK government, French government, German government to provide finance for coal phase out. And you can assume that there's probably more deals being done behind the scenes at the moment within India, Indonesia, Philippines, and Vietnam that will also help support their roll off coal as well. And this is a really interesting letter from 60 civil society organizations talking about some of their concerns they have on some of these deals coming out. So they go over what periods are coal plants being rewarded, what's replacing that coal when it's coming off, is there specific policies that's coming in place that means it's going to be replaced with renewables, how do you avoid that overpaying that we've been talking about with the German case, and how does civil society get a voice in this so that it's not just a case of these coal companies doing bilateral negotiations with very well off multilateral funds. So just to end on, all of the problem really comes from the fact that you want to force a closure of a coal power plant. Because if a coal power plant is economically closed, what we're looking at here is governments coming in, bringing in coal phase out plans, and then needing to reward companies to then compensate for them for the fact that they need to close. So what's the solution to that? Well, the solution is get creative. You don't need to come out with such an obvious mandate to force the closure of a coal power plant. In the UK, for example, the coal phase out that we have for 2024 doesn't actually mandate coal power plants to shut. It puts an emission standard on coal power plants below a certain level, which means that coal power plants can't operate, but it doesn't force a coal power plant to shut by itself. So therefore, that coal power plant operator can't bring a legal case in any way. So it's really trying to get a bit creative with how that is being implemented so that those companies haven't got a case to bring for compensation. And the other kind of set of mechanisms underneath this is also to make sure that that mandate, that closure isn't the only instrument you're using. You want to be using a variety of instruments so that to kind of shoulder that burden between the different bits. So it's not such an obvious case that a coal power plant goes from very profitable to loss making and therefore has such a big compensation case. So in the UK, we have a very strong carbon price, which took most of the profitability out of the coal power plant in the first place. There's all sorts of air pollution legislation coming in, which means that there'll be investments that need to be upgraded to that coal power plant. So legislation like that is still important that will undermine the economics, and therefore this compensation issue isn't such a determining issue. And thirdly, like ultimately what's happening here is the shift towards clean electricity, and the more clean electricity gets built, the less need there is for coal power, and the less profitability there is within for that coal asset in the first place to claim compensation for. So that's all I wanted to cover today. I hope there may be some follow-up questions on that, but lovely to be here and lovely to hear from the other panelists from their great thoughts as well. Thank you.
Great. Thank you, Dave, for your intervention and that detailed report. I see that there are a number of questions that have been logged, and they drill down into some quite technical areas. So before we start getting into some of that fine level of detail, I thought I would sort of reopen things up to the panelists in the first instance, and Martin, Kyla, Blanca, see if there are any points, proposals, insights that were raised by your co-panelists that you'd like to respond to before we turn to other individual questions from the audience. Kyla, you have politely raised your hand.
I'm sorry, I've been sort of trying to both listen to the presentations and answer some of the questions. So I'm probably gonna watch this recording again myself, but I like the idea of, be creative in order to avoid getting sued. But I'm not sure I believe that investors that get mandated to reduce their emissions, coal plant investors wouldn't be able to actually launch a case if they had an investment treaty protection. So are you thinking more in terms of like in the national context in UK law, they wouldn't be able to challenge that, or?
That's a question to me, right?
Yeah, sorry.
Yeah, no, it's in context of what does it mean for a specific asset. If you're a company with a specific asset and you're forced to close it, because, for example, the UK wants to phase out coal power, so it puts a mandate to close coal power plants, then you have then in some cases, depending on the law in that country, you might have a case to then get compensation for it. But if they find another way to force you to close that asset without explicitly telling you to close that asset, then there's ways to kind of get around that. But the context very much is at an asset level rather than a company level or a emissions target level.
Yeah, so I don't know if Martin or Blanca would agree, but I think that foreign investors or investors that have some coverage of investor treaty would still be able to find a way to argue that anything that reduces the value of their investment, even if it's not mandating closure, could still be challenged under investment treaties. So I just throw that out there.
I agree with you.
It's a question of how easy you make it for them.
Yeah, and it's the idea of a regulatory taking, right? Or a regular would be the analog in US law in any event. Any other comments or responses from the panelists? Okay, so why don't we turn things over to our Q&A, and I'll actually start with a question that I have that's a little bit technical, but maybe not quite as technical as some of the other questions in there. And this is about externalized costs, and I think in ISDS and Kyla and Blanca, I'll sort of point this to you on the technical level, and Martin, I wonder to what extent this also has implications for thinking about an equitable or just transition. Fossil fuel assets have externalized costs that are associated with them that are often not accounted for, as I understand it, in these compensation calculations, or specifically in the calculation of fair market value, which would be something like a social cost of carbon, the short-term and long-term contributions of these assets to the climate crisis itself. And I'm wondering from in the context of an arbitration, is there room for incorporation of those externalized costs into a calculation of appropriate compensation? Setting aside, Kyla, the primary questions that you ask, whether it should be paid at all and so forth and so on. If we get to that point, are there mechanisms available for that? So Blanca and Kyla, I wonder if each of you could respond to that, and Martin, if you have reflections, I'd be interested to hear that as well.
Okay, so well, as I said, there's a space in the calculation of compensation to count with decarbonization and climate changes consequences on assets. As a matter of fact, for example, price of oil can change because of what's going on with electricity electricity changing, will also more offered of oil due to the carbonization duties of the countries, etc. So it's going to impact. And on the other hand, you will also have maybe the assets would not have a long-term life because of the decarbonization, okay, of the necessity of the carbonization. So I think that in arbitration there are going to be more claims about that from the side of the investors, and also maybe on the dependent side of the governments, they will try to diminish what compensation is going to be calculated for the investors due to those categories I already mentioned.
Yeah, so I would just add that because the provisions on how to calculate compensation are so absent, so vague, there is scope, of course, for states to bring in experts. So you have to first of all have a state it's willing to do so, and because this is on the record, they might have political reasons for not wanting to put out there that they believe in the social cost of carbon or something like that. So that's one challenge. That's why it's also good if we can get non-party participation in these cases, because NGOs and people that care about climate can intervene and make those points without the government having to do so. However, often those briefs are ignored. There's only been a couple cases, I think, where they've actually been cited in the final award. But there is scope for those to come in. My concern is always how much appetite is there on the part of the arbitrators to accept those kind of things. They're not familiar with these things. They're not experts usually on climate and environmental issues. They're very much from the commercial law world, and they don't think about these issues. And so definitely we should push any states that are involved in these arbitrations to bring these arguments forward. But I don't think we should be necessarily optimistic that they will be accepted.
May I, Mike, just jump in briefly? So thank you so much. I would just echo what Kyla just said. I was just scribbling here. Is there room? Is there scope? Yes, there is. They should be incorporated, these externalities. I'm personally skeptical for the reasons that Kyla just outlined. And I'm feeling a little sneaky here to add on to my response, a reference to a paper that Kyla and Mike wrote just a couple of years ago, and that I had the pleasure to edit on valuing fossil fuel assets in an era of climate disruption. And in that paper, you alluded to the social cost of carbon, which you just brought up here, Mike, to remind us that that is one of the tools that, if tribunals were so inclined, they could consider to incorporate the externalities they're not taking into account, considering the costs inflicted by fossil fuels on society because of the global warming that they cause. And one of the studies that you cite in that review shows that the total unpaid social cost of carbon from 1995 to 2013 would exceed the fossil fuel sector's profits. So if tribunals were indeed to consider those externalities, this would essentially be an indication that this sector is not viable if it were to actually cover the costs that it imposes on society. I think it would be fantastic if we had this internalization of externalities to make a further case for what Kyla was also alluding to. Should these investors be compensated in the first place? Probably not. Just a quick note on that. Thank you.
Thank you, Martin. Thank you, everyone, for your responses. Let's stick with this issue for one more question, at least, which is a related issue in the sense that it seems to be getting at some of the technical elements of calculating compensation. So this question comes in from the Q&A. Thank you all very much for the informative presentations. I'll share that. Could you elaborate more on discounted cash flow as an evaluation method from an equity perspective? And so I'm thinking Blanca, Martin, Kyla, again, this might go to you, and Dave, perhaps you have something to add on this as well. As it happens, this is the standard used by almost all tribunals for FET violations. How do you think DCF, the discounted cash flow, should be adjusted to reflect distributional consequences of climate change? Blanca, would you like to potentially start responses on that?
Well, as I mentioned before, with the discount flow method, we can have some elements to consider, such as the price of the oil, such as the assets, how long would the investor be able to use those assets in the conditions that they have it. So there's room to calculate the compensation, but as Kyla says, I doubted that there is going to be a decision to do it. You must take into account that this method is highly speculative. I think that is highly speculative. So it can be used for everything. It depends on the decision of the tribunal, on the tendency to give investors what they want, or to allow states to make their point about protection of the environment. You have to take into account also that is obligation of the governments to take care of the environment. So sometimes during international arbitration, what investors said, well, it's not my responsibility, it's your responsibility. So I don't have to pay for it. You have to pay for it. Thank you.
So I would not say I have real expertise on DCF, but what I have read about it, I understand that the discount rate that you choose radically changes the amount that you come up with. And I would go with Professor Rob House's assessment that this is junk science. It's basically the investor's going to get an expert to give a rate that's going to give a huge award, and the state is going to try to give an expert that will have a lower one. And apparently what a lot of tribunals do is then just sort of go down the middle in an attempt to keep everyone sort of happy. I just think it's garbage. So that's my not particularly expertise view of DCF. I think it should be absolutely thrown out. So I don't think it could possibly be in a framework that's equitable at all.
When you're looking at closing coal power plants that already exist, there's no upfront big investment needed. You don't need to do it over a long period. What you're really talking about is whether you're shutting that asset 5 years or 10 years earlier, and you haven't got any big amounts of capital to worry about. So that valuation, so I'm not quite sure what the exact circumstances, kind of like you were talking about it, but from a coal power plant perspective, that valuation is really easy. You don't need to get into the technical side of that too much. Yeah.
Great, thanks everybody. So I have a question here that goes to an issue that's very much in conversation, at least here in the US and in the EU, and potentially in other places as well, around risk disclosure and corporate disclosure requirements. There has been growing pressure for companies to disclose climate risk, stranded asset risk in their financial reporting. could these developments be transposed to the context of investment treaty arbitration, leading to a meaningfully higher discount rate in application of DCF methodology? Or could stranded asset risk be assimilated into the discount rate for a country-specific political risk? Those are pretty fine-pointed questions. I don't know if you have specific answers to those particular nuances. That would be great. But I think there's also a broader question here about the relationship between climate risk disclosure and the prospects for this investor-state arbitration. Again, I'm guessing that this goes primarily Blanca and Kyla to each of you, but Dave and Martin, please do chime in as well.
I will start by making some reflections about the calculations that tribunal have done about country risk, and we have two sides on those considerations. The first one is the one that took gold reserve versus Venezuela and ConocoPhillips versus Venezuela, which where the tribunal examined the propensity to expropriate investment was to be borne by the state. And on the other side, we have the cases of Tidewater versus Venezuela also, and Saint-Gobain versus Venezuela, where the tribunals found out that the market's perception of the risk of expropriation ought to be borne by the investor. And that makes me think that when we are talking about risk of decarbonization or risk of whatever other risk that comes through the regulatory faculty that have the governments, we will have to see what tribunals go into, or go into the side that says the investor is the one that has to calculate the risk, and therefore that discount is against the investor, or the state is the one that is making the risk because they are regulating when the investor had made the investment under other rules. So we will see.
I think Blanca is clearly the expert on here, so I don't have anything to add to her answer. But if I might just go off in a slightly different direction about risk, I just wanted to note that the OECD is taking an interesting approach to now sort of framing investment treaties as a form of risk insurance. They essentially act as free risk insurance, and they're looking at whether therefore states should have to look at their treaties in the same way that now financial actors are being asked to look, insurance companies are being asked to develop net zero plans and so forth. So I think this is an interesting angle, the whole relationship between investment treaties and risk, and seeing them sort of as part of this whole discussion about finance and disclosure. It's completely separate from the question, but I just brought it to mind, so I'll throw it out there.
I don't think it's completely separate at all. I think it's quite a natural sort of digression. Let me ask, there's a question here directed towards Dave, which I think actually does touch Kyla a bit on the point that you're raising. Dave, the question for you was, has your report impacted outcomes? And is there a mechanism for challenging the compensation deal into which your data and analysis can feed? Which I think does sort of relate to the broader issue of, ultimately, are there mechanisms to challenge these compensation deals or awards as they arise either from domestic agreements, like in the Germany context, or from arbitral awards under investor-state dispute settlement? So Dave, to you first.
It's a great question. Whoever it was, it comes up as anonymous, which is a shame. But unfortunately, I don't have a great answer for it. And the biggest reason why is I've this is Sarah's little baby, and I've been helping on site, so she'd be able to answer that question far more articulately. I'm afraid. I guess our theory of when you're talking about what's changed, our theory of change is to be working with two sets of actors. One is the media, because there is a sense of narrative in all of this about the acceptability of this and getting the story out here that these cases are being challenged. And then the second set of actors is with legal NGOs. So within Europe, the ones active on coal, the biggest one you've heard of is probably heard of is Client Earth, and then there's File, and then there's Frank Boyd, that are all like very much our bread and butter of people that we're constantly helping behind the scenes in the cases that they're doing, that they can bring up. So they're doing the actual physical legal work and all of this. The reason why we're doing this, the reason why those legal companies are so involved in this is in part to challenge these decisions, but it's really to make it hard, make it unacceptable, and to shape that whole narrative about the unacceptability of payment of compensation for fossil asset shutting. What we don't want is, we don't want this precedent, like so these payments are happening within Europe, specifically on coal, are some of the biggest in the world. What we don't want is this precedent that fossil assets are being paid to close. It's going to slow down the electricity transition. It's going to make it a lot more expensive. It's going to put the wrong onus on electricity, on energy company and fossil companies that use fossil fuels to do the right thing. It's going to encourage them to use them longer and wait for a bailout from the government. So from our perspective, that's our theory of change, and that's why we want to make such a big deal of it.
Okay, thank you, Dave. I think that this also raises for me a related question as to the different situations that domestic investors and foreign investors find themselves in under these regimes. It does seem to me, as somebody who's not as deeply steeped in this as any of you are, that foreign investors wind up with quite a distinct advantage over domestic investors when it comes to the energy transition. I see heads nodding. So I guess I'm not quite sure what the question is there, but perhaps this goes to the point of reform that Kyla and Martin brought up. Is that in fact the case, that foreign investors simply have access to compensation where domestic investors do not? And as that seems to be the case, what can be done about it? Because it doesn't seem quite right? I'll throw that out to the group.
Well, that's right. That's the reason why Brazil haven't signed any BIT, because they consider that signing BITs would allow foreign investors to be in a better position than the one that has domestic investors. And that's one of the big questions about the investment settlement dispute system. Why does foreign investors have more privileges than domestic ones? But that's a reality. That's the way it is.
Yeah, I would just add that in addition to Brazil, so the Labour Party in Australia, which is not currently in government, but might be after May, who knows, has an official position against ISDS. And one of the reasons is not just the concerns about the right to regulate and so forth, but the union movement there really pushed very hard on this issue that domestic investors should not be considered less worthy. I mean, the original basis for this whole regime was about the idea that foreign investors were somehow disadvantaged in countries that they go to because they didn't have the same kind of political access and so forth to governments. But most of those arguments have been completely debunked by research, and it's been found that there is really no problem that these treaties are solving. So that's why I always fall back on, we should just get rid of them.
It was a really interesting question, Michael, and away from the legal side, that I think the context that we're talking about from a company, if you look at RWE and LEAG, they've got friends in the government want those companies to survive and not go bankrupt. They're happy to pay those companies over the odds and not worried about trying to keep those compensation payments as low as possible. When you look within China, the utilities within China are now undergoing, the biggest coal power utilities within China are undergoing a major transition into wind and solar. So, and that's being really forced by the government. So rather than the government coming down and giving sticks for closure, it's giving carrots to move into renewable electricity. And certainly those carrots, there would be more sticks for foreign companies and less carrots for foreign companies for that. So from a legal perspective, it may be different, but just from an overall perspective, governments don't want these companies to go bankrupt. They're more, they have connections for these companies that run deep. They want them to survive. They're happy to give them more compensation than they're most likely due.
Absolutely. Excellent point, Dave. Thank you. So we have just a few minutes remaining here. And what I'd like to do at this point is offer each of the panelists an opportunity to give any final concluding remarks that you may have. The questions, I think we've touched on most, if not quite all of them. And there's more that are just coming in, but we only have a few minutes left, and I'd like to give each of you a chance for any sort of final reflections or thoughts on the conversation. So Martin, do you mind if I start with you?
Sure, thanks, Mike. I was just thinking of going back to the choice of the discount rate and the DCF method. I don't claim to be an expert in the issue. I see lots of questions in the chat that are trying to work it out. Well, what should this discount rate be, and can we work with that to bring more accurate valuations of fossil fuel assets in investment treaty arbitration? If we are going to go down that route, and I think we've made a few arguments here that that's probably not the optimal route. I just remembered as we were talking about this debate between Stern and Nordhaus, Nobel Prize winning economists a couple of years ago, precisely about the choice of the discount rate for climate mitigation. One advocating for a much lower discount rate, which would lead to much more aggressive action, a much higher social cost of carbon, and one arguing for a much higher rate, leading them to, more relaxed. We have more time, the cost is lower, climate action is not as urgent. And even between economists, this is a complex issue that turns to an ethical question, and ultimately an equity question, going back to my initial point of how we value future generations, and how much weight do we give to their well-being as opposed to our present well-being. And my final point would be, rather than trying to sort that out, if even among economists that's complicated, why not make that ethical decision and impose in a way in these treaty-based valuations the discount rate that would be desirable for the appropriate valuation. If it is ultimately not a matter of economics, but an ethical choice, why not evaluate that path? Just a quick contribution to wrap up. Thanks.
Thank you, Martin. Kyla, final words.
Yeah, so much to go on, but just building off what Martin's just said, I would definitely say we do need to make sure that we impose. I think we can't leave it up to tribunals and states to raise the right issues case by case, because it just creates far too much uncertainty. And my main concern is always still that that uncertainty about whether or not you're going to be able to win an investor challenge will lead to either a chilling effect, which is the worst possible outcome because we need action, or overcompensation, which diverts the necessary resources that, as Martin outlined, we need to go to workers and communities and towards the the technological shifts and so forth that we need to invest in. So I definitely think we have to either get rid of the treaties or impose really hard rules on them. The problem is the politics of getting there. Thanks very much.
Thank you, Kyla. Blanca.
Well, I agree with both of Martin and Kyla. I think that the solution is not within the arbitral tribunals, although they may face the questions through the parties in the arbitration proceeding, and we don't know what they are going to decide. And that's the uncertainty that we don't want to. As a matter of fact, what I think is that we must try to make our countries to reform the treaties, to incorporate on them the discount because of decarbonization, for example. To get rid of treaties, I think it's kind of hard. As a matter of fact, Ecuador did it. But right now we have another government, and this government says, well, no, investments are not coming to our country, so we need new treaties. So I don't know what is going to happen in the political aspect of getting rid of treaties, but I'm quite sure that it is more feasible to have a reform of the treaties, taking into the account these issues.
Thank you. And Dave, last word goes to you.
I still see it as the responsibility of the governments to not get into the situation they ever need to give out compensation payments. I don't like, they need to get creative with the ways to guide this process, that they be clever about it enough that this should never happen. Fossil companies don't deserve money to be compensated for assets they've had due notice on, that they know can't be operating in a future carbon constrained world. The second part to that, which is governments can also play a role in minimizing the extent of those compensation payments as well. So rather than just blindly pay them, it needs to be going through having a carbon price in there, like a national, all sorts of the other ways to reduce the actual profitability, and then also to be really involved in that negotiation and the court case to make sure that they're not overpaying. That's my 2 pennies.
All right. Well, thank you, Dave. So everybody, please join me in thanking our panelists for this great set of presentations and discussion. I'll say a quick word of thanks to the Columbia Center on Sustainable Investment and Sabin Center for Climate Change Law teams for the effort in pulling this together and working on the comms and the tech side of things. And with that, we will adjourn just 2 minutes over time. So thanks again, everybody, and have a great day.
Thanks to you. Thanks to Columbia University for this panel. It was very, very interesting. Thank you.
Thank you, everyone.
Thank you.
Nice to meet you all.